Hello, everyone. Welcome to the BWF Solicitors platform on Facebook and all of the other platforms as well. This afternoon on our flagship program, The Community and the Law, we have been discussing Ghana customary marriage and its impact on UK immigration law. Now, we've discussed what constitutes a valid marriage or valid customary marriage under UK immigration law. Now, the law allows for us to marry under our customary rules. So if you're Ghanaian and you want to marry at home within the traditional settings, then the law allows you or permits you to be able to do that. And you are not supposed to be two Ghanaians contracting the marriage. So effectively, you could be a Ghanaian and a non-Ghanaian contracting the marriage, and the law allows that. Now, an ingredient or the ingredients that constitute or validates a customary marriage includes a consent from the bride and consent from the groom. You'd also require the family's consent. So the man's family and the woman's family would have to consent to that marriage being contracted. And then you would want to carry on with what we would call consummation. What it simply means is that both of you are living together as a family in the eyes of the rest of the world. And so the world sees you as a couple. There's a case law that supports this called Yaote versus Kwe. This is a case decided in Ghana in 1961 and is still valid till today. Now, the UK law, that is Section 46, the 1986 Family Law Act, basically states that if your marriage outside the UK had followed the lay-down procedures in the country where it was contracted, then when you bring that marriage to the UK law would accept that marriage as well. So what are we talking here? Now, for your marriage to be accepted in the UK, then you are required to follow through with the processes laid down in Ghana law. Now, once you are married, there is no requirement at all for you to register your marriage. However, you have the discretion if you choose to do that. So under our Marriage Act of Ghana 1884 to 1985, Cap 127, there is no requirement for you to register your customary marriage. But for your immigration purposes, if you choose to register your marriage in that regard, then the law allows you to do that. Again, if you had not done that when you married, you shouldn't worry at all, because then, because it is discretional, the law allows that you could do that registration even years after you had done the marriage. And so, for instance, you married in 2019 and you did not register your marriage then, because then you did not want to do that, because the law didn't require you anyway. However, now, you know you want to come to the UK to come and join your EEA national who is settled here in the UK. And so now you have chosen to go and then register your marriage. The law allows you to be able to do that. So what you do is you elect your representatives who would go to one of the local marriage registrars and then register your marriage. This would include them swearing a statutory declaration. Once they've done that, they will be issued a marriage certificate, and the significant date that we're looking at on that marriage certificate is the date of marriage itself, not the date of registration. Please note this. It's the date of marriage that we're looking at, not the date of the registration. So the date of marriage precedes the specified date when we were supposed to have formed our relationship back then in December 2020, 31st at 11 p.m. So if that date of marriage precedes that, then indeed, date when you registered your marriage is irrelevant, because the case law basically says that it is not the registration of the marriage that gives it its relevance. Yaote versus Quay. So if that is the case, then if you register your marriage today, the Home Office has got no business whatsoever at all questioning why you're registering your marriage today. And that has been set right there in the UK law, and UK Home Office's guidance also makes that very clear as well, that proxy marriages would be accepted here in the UK so long as they've gone through the proper lay-down procedures in the country where it was contracted. So if you are in such a situation, please don't worry at all. You can always approach us. You can always speak to us. Let us know what the issue is, and we will try as much as we can to resolve it for you. The reason we are propagating this information is on the basis that the Home Office has started refusing applications on the basis that it was registered in 2021. And so for that matter, you were not a family member at the specified date, which is 31st December 2020. We're saying they are wrong. We've started challenging them. And so we're asking you to come see us if you have a situation like that, so that we'll be able to help you. You know where we are. BWF Solicitors, 4th floor of the Anna House. That's 214 to 218, 214 to 218, Seven Sisters High Road. The postcode is N14, N15 4NP. My apologies. So N15 4NP. And the telephone number to ring us on is 0208 493 7340. 0208 493 7340. Please do not hesitate to speak to us if you're in such a situation. And indeed, if you have any other immigration issue or legal issue at all, you know where we are. Please give us a call and we'll be more than happy to help you. Thank you very much for listening. Please join us again, same time next week, on another edition of the Community and the Law.